Good morning, everyone. My name is Witness Makhubele. I'm a partner in the Corporate Commercial Department at ENSafrica. And we are welcoming you to our webinar today. The topic today is one of those interesting topics. It's about making borrowing and lending safer. The issues that we're going to be talking about relate largely about public sector financing and borrowing. And maybe before I get to the formalities of today, just want to tell you a little bit about ENS. ENS is Africa's largest law firm. We have offices across the continent, in Ghana, here in Joburg, in Mauritius, Kenya, Uganda, Rwanda, and Namibia. And with the kind of expertise that we have, we are able to assist clients across the continent on very deep matters that require deep expertise in legal, tax, finance, and IP, as well as forensic matters. We are recognized as a leading law firm across the continent, and we've been involved in very interesting and complex transactions across the continent. In today's webinar, I have my colleagues who are experts in their own fields, and they will be talking to us about their experiences as well as matters that they may have come across in relation to public sector borrowing and lending and how to make it safer. My colleagues that will be taking us through the discussion today are Pippa Reyburn, Vusi, Mathebula, and Anina Boshoff. In relation to how we're going to have this discussion today, Pippa will start with the discussion, and she will be talking to us about the matters that would need to look at, give us an overview of regulatory framework for public sector borrowing. Pippa is a partner in the Corporate Commercial Department, and she's focusing on public law and is an expert in the regulatory aspect involving public sector financing. After Pippa, Vusi Mathebula will also talk to us about what matters that we need to consider when lending to borrowers who rely on government contracts to repay the loans that they might have been given or advanced to. Vusi is a partner in the Banking and Finance Department, focusing on financing in all aspects, public and private sectors. After Vusi, Anina will then give us an overview of practical aspects that one would need to look at when closing and enforcing public sector loans. Those are the matters that we're going to be looking at today. But before we start with the discussion today, just want to give you a bit of what to expect in terms of our house rules today. We will take questions right at the end of the discussion. Can I ask you to post your questions on the Q&A box, and we will then take those questions for our distinguished panel right at the end of the discussion. You will be able to change your questions if you want to before we read out the questions, and you can put the questions in an anonymous basis. Without further ado, I would call upon Pippa, ask my colleague Pippa, to then talk to us about how to make borrowing and lending safer and the framework, the regulatory framework around public sector borrowing. Thank you.
Morning, everyone. So I'm going to do the public sector borrowing 101 section. It's mainly the PFMA that I'm going to talk about. Obviously, there's other legislation that is relevant, and I'll refer to that as we go along. So for purposes of talking about public sector borrowing, Organs of state broadly can be classified into various categories, and I'm going to mention them briefly before talking in more detail about public entities. So the categories, I'd say, are government departments at national and provincial level as one category, then state-owned enterprises or public entities, as the PFMA calls them, and those also occur at both national and provincial level. And then finally, municipalities and municipal entities, which are separately regulated. So very briefly, government departments do not borrow individually. So at national level, borrowing is done by the Minister of Finance on behalf of National Treasury for RSA Inc. Provincial government borrowing is regulated also under separate legislation, which is called the Borrowing Powers of Provincial Governments Act. But provincial government is actually centrally coordinated on an annual basis through a committee which is chaired by the Minister of Finance. So provinces' borrowing is also centrally coordinated, and they don't borrow individually outside of that framework. And then municipalities and municipal entities can both incur short-term debt and long-term debt, as those terms are defined in the Local Government Municipal Finance Management Act, the MFMA. And that procedure, and according to a specific procedure set out in that act, and that procedure requires the approval of the municipal council or the board of the municipal entity. And in the case of long-term debt, also requires a public participation process prior to the final decision to incur long-term debt. So that's a whole separate regulatory framework, and I'm not going to talk about that today. I mean, that could be the subject of a whole other discussion. So for the rest of today, I'm just going to talk about public entities in their various categories and borrowing by them and lending to them. So public entities, in terms of the PFMA, are defined and classified in various categories. So there are two main subtypes of public entity. The first is colloquially known as a non-business public entity, and the second as a national or provincial government business enterprise. So there's non-business public entities and business public entities. And each one occurs at both national and provincial level. And the four subdivisions of Schedule 3 of the PFMA are linked to those four categories. Then there are also what are called major public entities, and those are listed in Schedule 2 of the PFMA. And those could be of either type. So they're not divided, unlike the others, into business and non-business public entities. Most of them would probably be considered government business enterprises rather than non-business entities, but you have to actually look at their functions and governance relative to the definitions in the PFMA in order to confirm which those are. And the major public entities include all the big ones that we all know, like Eskom, Transnet, AXA, Broadband, Infraco, the Central Energy Fund, Denel, and then the DFIs, DVSA, IDC, Land Bank, and then some others like the Nuclear Energy Corporation, SABC, the Post Office, SAA, Trans-Caledon Tunnel Authority. And then it's also important to note that any entity which is either a subsidiary of a listed public entity, listed in the sense of in a schedule to the PFMA, or is under the ownership control of that public entity, is also considered to be a public entity in the same category. So even if you're a tiny little subsidiary of a major public entity, you're considered to be a major public entity and have to comply with all the duties, and you have all the entitlements of a major public entity. Okay, so that's how the PFMA classifies them. But it's very important to also know that most of those public entities were established by specific legislation enacted for the purpose of establishing that entity, and that's commonly known as empowering legislation or establishment legislation. So each of those public entities is subject not only to the PFMA, but also to the specific empowering legislation in terms of which they were established. And then also, if they're structured as companies, they're subject to the Companies Act. So from the perspective of financial affairs, governance structure, directors, duties, you have to look at all three statutes, usually when you're dealing with a big SOE that's a company, in order to work out what the parameters of the powers and duties of those entities are. So the main provision, or the only provision really, regulating borrowing by public entities in the PFMA is Section 66. And Michael Katz told me this morning he's seen 50 legal opinions about Section 66, and they all say something different. So Section 66 is complex, and it keeps surprising us. It's almost the 21st birthday of the PFMA, and some of us have been working on it for all those 21 years, and it still has the capacity to perplex and surprise us. So don't be don't be upset if this sounds a little complex. But in terms of Section 66(1) of the PFMA, a public entity may not borrow money or conclude certain other transactions, which I'm not going to discuss today, unless the borrowing or those other transactions is authorized both by the PFMA and by other legislation not in conflict with the PFMA. So when you're either dealing with a public entity or working out what the powers of a public entity are from within, step one is to work out whether the public entity concerned has the legal authority to borrow in terms of the PFMA itself. That's the first condition. And Section 66(3) of the PFMA regulates which categories of public entity have borrowing powers and the restrictions or approvals or requirements that apply if they do. So what it says is that a public entity listed in Schedule 2, so that's the major entities, may borrow money, but only through their accounting authority, which is their board of directors. So they're the ones that have the most autonomy as regards borrowing. Then national government business enterprises, which are the category of public entity that's meant to be largely funded by revenue sources other than the state. So those should have more, you'd think, financial autonomy. They have to be authorized to borrow money specifically in the Government Gazette by the Minister of Finance. And once they've been authorized to do that, then they may borrow money through their accounting authority or their board of directors, subject to any conditions the Minister of Finance may approve or may impose. So when the Minister of Finance authorizes them to borrow in the Government Gazette, he or she may impose certain conditions or restrictions on borrowing. And examples of public entities that have those powers are the water boards. So those public entities generally are authorized to borrow by notice in the Gazette, and those notices are replaced from time to time by the minister who sets new borrowing limits from year to year or every few years for those water boards. Another example is PRASA. When it entered into its big train contract, it was authorized to borrow money and do these other transactions specifically for purposes of that train transaction, whereas in the normal course, it wouldn't have the power to borrow. So that's national government business enterprises. Then national non-business public entities may only borrow through the Minister of Finance. So that's, they don't have to be authorized by notice in the Gazette, but the Minister of Finance has to approve their borrowing. Provincial government business enterprises also have to be authorized by notice in the Gazette by the Minister, and then they're entitled to borrow through their MEC for finance in the relevant province, acting with the concurrence of the Minister of Finance. So that's a double authority for provincial business enterprises. And then finally, provincial non-business public entities and what's called constitutional institutions, which is a separate list under the PFMA, are not entitled to borrow money at all. So So it's very important when you're dealing with a public entity to establish upfront which category it falls into and whether, as step one, in terms of the PFMA, it's entitled to borrow and under what conditions. Step two then is to look for the second level authority to borrow, because as I said upfront, Section 66 of the PFMA requires that public entities be authorized to borrow not only in terms of the PFMA, but also in terms of another piece of legislation. So in most cases with public entities, or in many cases, that second authority is the Companies Act, because unless they're restricted, they would have the general powers of a company, which includes the power to borrow. But not all public entities are structured as companies. Some of them are statutory corporations, and then their borrowing powers would normally be regulated by their establishment legislation, which sets out their overall powers and functions. So that's step two. And then, but even in the case of a public entity that's structured as a company, so you've got the two levels of authority to borrow, both under the PFMA and under the Companies Act, you have to look at the empowering legislation in order to see that that doesn't impose some kind of additional restriction or requirement in relation to borrowing that the board would also have to comply with. For example, the requirement of a ministerial approval or borrowing within a certain limit. So all three sort of sets of governing statutes are important in relation to establishing the power to borrow and the constraints of that entitlement. So then if we look at section 66 of the PFMA, 66.6, sorry, that's relevant for the Schedule 2 public entities. So that's the big ones, where section 66.6 says that the person authorized to borrow on behalf of a public entity, so that would be the board in the Schedule 2s, may not delegate that power except with the written prior approval of the Minister of Finance. So those boards have to obtain the minister's approval in order to be able to delegate the power to borrow to executive management or the CFO or whoever it is that they want to delegate that power to. In the absence of a Minister of Finance approval, the board itself would have to approve every act of borrowing. So most of the big Schedule 2 public entities received authority to delegate when the PFMA first came into operation. And for some of them, that authority has been substituted over time to reflect more recent governance structures, changes in governance structure, etc. So those boards have to receive the Minister of Finance approval and then actually delegate that authority to someone in order for that person to have authority to borrow. Then last, on section 66, section 66.7 says that a public entity which is authorized to borrow must annually submit to the Minister of Finance a borrowing program for the year in question and may not borrow in a foreign currency above a prescribed limit, except where the state is not the only shareholder of that public entity. And to date, there's no general limit that's been prescribed for foreign currency borrowing. But we have seen recently borrowing limits, foreign currency borrowing limits being set by means of letters from the Minister of Finance. And Section 67 prohibits provincial public entities from borrowing money denominated in foreign currency or concluded on foreign financial markets at all. So it's only at national level that there's any entitlement to borrow in foreign currency. Section 68 is important because it provides that if a person lends money to an institution to which the PFMA applies, otherwise than in accordance with Section 66, the state and that institution is not bound by the lending contract. So that's obviously placing the risk on the lender in relation to borrowing by SOE. So it's up to the lender to ensure that where they lend, the proper authority is in place. So the consequence of all these provisions is that the only public entities that can borrow more or less freely, provided their authority to borrow is not restricted in terms of the empowering legislation or constrained in some way, are the Schedule 2, the major public entities. And then, as I said, certain others have been authorized to borrow for specific purposes or up to specific limits by notice in the Gazette. And then I want to reiterate the point that in the case of borrowing by public entities which are set up in terms of specific empowering legislation, there may be additional procedural requirements which apply. And then finally, you can treat this as step 3. There may be restrictions or other approvals that are required in terms of ancillary instruments. So not in the legislation itself, but it may be in regulations to the empowering legislation, or it may be in the MOI of the public entity. There've also been restrictions imposed in terms of a government guarantee framework for a particular public entity. And then sometimes in the annual shareholder compact, which is agreed between the board of the public entity and its executive authority, so its minister from year to year. So all of those may constrain the internal authority of the public entity to borrow. And it's a complex legal area as to which of those constraints would be binding on third parties or would invalidate a lending contract. And we can talk about that later if there are questions. But basically our interpretation of the PFMA and the way we apply it is that it's important to read all of those statutes together and to treat constraints and approvals required in terms of establishment legislation as being cumulative to the PFMA requirements when you're looking at total authority to borrow. So I think I'll stop there and let the clever people go on about the more specialized areas. Thanks, Witness.
Thanks, Pippa. Much appreciated. And I think the legal framework is really, really important for both the borrowers and the lenders to really understand what is it that a public entity would intend to do in terms of any regulatory framework that applies to it, as well as lenders to understand whether they can or cannot lend to that public entity. Vusi is going to then talk to us about what is it that borrowers would need to consider where, for example, they rely on government contracts for purposes of repayment of loans. Thanks, Vusi.
Thank you very much, Witness. And I think good morning and welcome to everyone, and thank you for joining this session and our discussion today. And essentially, my discussion focuses more on what lenders need to look at when funding or providing finance to a borrower that is relying on a contract from government or an organ of state. We've seen increasingly, or this becoming an increasing area of business for lenders. And traditionally, lenders would focus on looking at the particular entity from a credit perspective and whether or not they should be providing money to that particular entity depending on how good their credit is. So maybe let me start by saying, government is considered to be the largest procurer of goods and services in most countries, and certainly in South Africa, because government generally touches every aspect of our life, from agriculture, technology, financial services. Basically, government is a large conglomerate. I think the South African government alone spent over 1.7 trillion in the 2019 financial year, if the numbers that are available publicly are to be relied on. Inevitably, government will not have the capacity to provide all of the goods and services that are required by government to fulfill its mandate, nor will it be efficient in all instances for government to do this work itself. And what tends to happen is that government will then employ third-party service providers to provide these goods. And quite often, these are actually large services or goods that are required to be provided. And the service providers themselves do not have the capacity or the funding to implement some of these projects or services or goods that need to be supplied and provided. And what will happen is these providers, or third-party service providers, will approach lenders for funding based on the contract that they've been awarded by government. The lenders will then consider these contracts and provide some sort of a discounted funding arrangement solution to these third-party service providers, looking at the future value of the contract and what the repayments will be, and how the lenders get repaid will probably mimic the profile of repayment for these particular service providers from government. Inherently, there's a risk in that, what the lenders then rely on, or part of what the lenders rely on, is the contract that the entity has with the relevant government department or organ of state. And if there's anything that is considered to be wrong with that contract, or there's a dispute that arises in terms of that contract, lenders are typically one step removed from the action, in that they're not the main parties to the agreement, which leaves lenders sort of standing almost outside in the cold as things unfold in terms of a dispute. So what are the things that lenders can do to protect themselves? Well, it goes without saying that a proper due diligence would need to be followed, or proper due diligence would need to be concluded as far as how was the contract obtained and was due process followed in obtaining the contract, right? And in obtaining the contract, I don't think I need to reiterate this, but I will, just for purposes of this conversation, that any goods or services that are provided by the state, or with the state goes out to give contracts, that a fair and equitable process needs to be followed. And that is in terms of section 217 of the Constitution, right? And also of the PFMA, to ensure that there's fairness, equity, transparency, and there's a competitive process that is followed in providing contracts. I'll not go into the details of the exceptions, but there are certain exceptions in certain instances where people can deviate from following the process. But the base is that when government provides goods or services, there's an open tender process that needs to be followed. So in ensuring that that particular contract that is awarded to the party that is seeking funding from lenders are required to sort of follow a due diligence, or perform a due diligence, in ensuring that that particular department or organ of state that is giving that contract has followed the necessary process that needs to be followed in awarding that contract. Right. And lenders also need to make sure that in looking at the credit of the company, they also take security where they can, to secure themselves, whether it's the actual assets in instances where there are assets that are being procured by the third party service provider, and if possible, security provided by personally by the shareholders of the company where that is possible. And that is to ensure protection if it is found at some point that the contract that has been awarded is invalid. And why are we actually talking about this? We're talking about this because where the contract is found to have been invalid or process has not been followed in awarding the contract, the loan that the lender has provided typically sort of follows the contract, if you will. So if the contract is found to be invalid for any reason, the lender may find itself not being able to recoup monies that have been advanced to the particular party, as there may be no repayments that will sort of continue. And that depends on what happens in the court process in finding that a contract is invalid. There are typically two things that a court will look at, and that came out in the decision of Ope and Kichima. The first is that the court will look at what is the default position. when a contract has been awarded and it is found that the contract is invalid. And the court, in looking at what the default position would be typically to almost undo the contract and restore sort of the parties to the position in which they were in before the contract. But in doing that, the court will take into account the work that has been done, whether they're innocent parties, you know, that are involved in the court processes, and how far along the contract is, and whether it will be in the public interest for that contract to be considered invalid in total, and whether it's possible to restore people to the position that they were prior to the contract. In the Gijima case, interestingly, the court looked at what is called a just and equitable remedy, that in the interest, or would it be in the public interest, and would it be just and equitable to find that the contract has been, that a contract has been entered into in a way that is contrary to what is required, and what would be the consequences, of that, and that in that instance, would it be just and equitable to either, revert to or to making the contract invalid, or even in certain instances, continuing with the contract if there's an innocent party and where there hasn't been any fraud, etc., in providing the contract. Interestingly, in a more recent case of the Central Energy Fund in the Western Cape High Court, the court looked at both of the remedies in the all-pay case, which is whether the contract should be declared invalid, or the Gijima principle, which is would it be just and equitable in the instance to set aside the contract. But in this instance, the court also assessed whether there should be the purchase price should be restored, or whether or not there can be compensation for losses, and whether or not lenders would be allowed or financiers would be allowed to join the proceedings. And in the instances of lenders being allowed to join the proceedings is quite unclear. Which is why lenders would be required to sort of ensure that they perform a proper due diligence on the awarding of the contract, and to take security as much as they can in respect of that contract, because the court looked at the particular circumstances of that case. And under that case, there was a tripartite arrangement that allowed the financier to be a part of that case, or the litigation in that case, which would not happen in normal circumstances, and the lenders would find themselves sort of sitting outside the cold and outside of the process. Where does that leave the lender, where you can't be a party to the case and have your sort of side of the facts heard? It leaves you really with a delictual claim against the party that you've advanced funds to. And lenders may find that that particular party, or the parent companies, do not have sufficient funds to pay out lenders if it is found that the contract that the lenders provided funding based on is found to be invalid. So it is important, and I cannot stress this enough, for lenders to go on a thorough due diligence process when providing funding that is linked to a government-backed contract, if you will. And, where possible, to take security, to take hard security, and to take personal security where that is possible. So that you don't, as lenders, find yourself sitting outside in the cold if a contract that has been provided to a service provider is found to be invalid by the court, and there can no longer be payments made going forward, which will aid in satisfying any debt obligations that are still owed to the lenders. And that's my piece for today, witness. Thank you.
Thanks very much, Vusi. Vusi's piece is also very, very important, in the sense that whilst it's important for lenders to do a DD on their clients or borrowers to see and ensure that proper process has been followed by government in awarding the contract, it's critically important for the borrowers themselves to ensure that process has been followed by the public entity, so that the contract does not it's not prone to being cancelled for any matters that may not have been properly dealt with. And it's also important for government as well to ensure that they follow their own processes, public entities to follow their own processes, because if the contract is cancelled, they're not going to get the services for which they had issued the tender. So for all those three parties, it's important that processes are followed appropriately to get the best out of the contract. Without further ado, I'll request Anina to just give us an overview of the practical aspects of closing and enforcing public sector loans. Thanks, Anina.
Thank you, Witness. I'm going to focus on some very practical points to bear in mind both by public sector lenders and their borrowers in relation to closing transactions and enforcing them. So some of what I'll do is really focusing in or zooming in on principles that Pippa has already explained, and to make it practical or easy to understand, I will try to create some analogies with private sector funding, which I think in most respects are somewhat simpler. So because SOE loans in South Africa are raised mostly by Schedule 2 PFMA entities or major public entities, I will focus on them. And I'm going to refer to loans throughout, but remember these principles apply equally to public sector debt issuances. Okay, closing deliverables, CPs. These are critical things for lenders in reducing their risk. So thinking of a private sector debt transaction, they would at least include the following in relation to the borrower, and if there's a guarantor, the guarantor. Constitutional documents, which show where and how the borrower was established and what its powers are. A board and often a shareholder resolution to show the actual authority for the specific transaction. There's always a certificate or confirmation from a company secretary or other authorized person to confirm factual things that the lawyers can't check. And then there's a legal opinion to confirm the analysis, both on capacity and authority, but also on the validity of the agreements, the finance documents against the borrower side entities. Other common closing deliverables, aside from a complete, properly signed set of documents, would be the borrower's annual financial statements, its budget as approved by its board, and a base case financial model. So turning to public sector borrowers, of course, they also have to show where and how they were established and what their powers are. But only public entities incorporated as companies like AXA, Eskom, and Denel would be able to deliver an MOI, a Memorandum of Incorporation. As Pippa mentioned, public entities established by statute, that would be the DBSA, the Land Bank, Nuclear Energy Corporation, would instead provide a copy of its empowering legislation. For all of them though, whether you're a company or not, and whether you're in the provincial or the national sphere, both the Constitution of the Republic of South Africa and the Public Finance Management Act is equally relevant to the analysis of your power and your authority to borrow externally. South African public entities all have boards of directors or equivalent governing bodies, and these are referred to in the PFMA as their accounting authorities. And as Pippa explained, major public entities borrow through these boards or through these accounting authorities. In reality, though, the boards of most major public entities have only a small number of executive directors. So, for example, 8 of Eskom's 10 directors are non-execs, and 10 of AXA's 12 directors, this is according to CIPC records, are non-execs. And because these entities have very active borrowing programs and they raise tens of billions of rands every year, it makes no sense to involve the entire board in the detailed negotiation of their loan documents. It doesn't even make sense to involve them in approving every transaction. And for this reason, they rely on standing delegations of authority from the board to specified officers. So a lender who expected to be given a bespoke board resolution that approves a specific transaction and who questions these standing delegations that we tend to rely on would have to be provided at least the following to give them some of the comfort they would have had if it were a private entity: the PFMA, evidence that the Minister of Finance has authorized the board of the public entity borrower to delegate powers to individual officers. That's the section 66(6) approval referred to earlier. Then evidence of the management powers of the board, including that it can delegate powers. So in its MOI or in its empowering legislation, the general powers of the board would be explained. Then there has to be a resolution in terms of which the actual delegating of the authority is effected and to specified officers. And then one to look out for is if the resolution refers to any other documents, this is the delegating resolution, be that a borrowing program or something else, those documents also need to be delivered and interrogated. So some practical issues, foreign lenders very often ask for evidence that the standing section 66 authorizations or approvals to delegate borrowing powers and the standing resolutions from the boards to the officers, typically in terms of a delegation matrix or some such, that this hasn't been revoked. Okay, this may be, Pippa mentioned that these things, some of them were issued right when the PFMA was promulgated and enacted in 2000. So some of them have been in place since then. Equally with board resolutions, they're not adopted very often. So we sometimes see a delegating board resolution in place for 3, 4, 5 years, and that it does seem odd, but National Treasury doesn't go about issuing confirmations that it hasn't revoked section 66 authorities or approvals. So this is something that needs to be explained to lenders at the outset. In terms of standing delegations of authority, that's somewhat simpler. It should be possible to approach the company secretary or some other authorized person in a public entity to provide a more recent extract of that board resolution, even if the resolution is old, with a confirmation that it hasn't been revoked. Another practical issue, CIPC doesn't hold records for public entities that are not incorporated as state-owned companies. There are 1 or 2 exceptions, so IDC is an example, but that is because it's specifically its own legislation authorizes or instructs CIPC to hold records. But generally speaking, no CIPC searches can be done for public entities that are not statutory corporations. So what this means is the information that you would normally obtain from CIPC, and these are basic things lenders want: who's the board of directors, who are the auditors of the entity, is the entity still in business? These bits of information need to be obtained in another form, either directly from the entity or through showing a legal analysis and presented to lenders in a way that is acceptable to them. Moving on to other types of CPs and closing deliverables. Under a loan to a private sector company, you would always see original financial statements, budget, base case model. These documents essentially provide a day one financial position picture of the entity, but it also serves as a reference point for measuring covenants over the life of the transaction, and it gives some kind of projection of future performance, and often it's also used to cross-check or to disclose existing indebtedness of the entity. So public sector borrowers, of course, are also required to deliver annual audited financial statements, but instead of a budget or a base case model of both, they would typically deliver a borrowing program, a corporate plan, or both. The borrower's corporate plan would be its most recent annually submitted plan in terms of section 52 of the PFMA that is submitted to its executive authority. And that is the responsible minister for that department. And it would include a budget and projections of borrowings for the upcoming financial year. The borrowing program is a different document. It's submitted annually to the Minister of Finance, but you might find, and that's under section 66(7) of the PFMA, but you might find in practice that they overlap or even that they are prepared as a single document, but they're very important for lenders. A practical issue that arises from these documents is whether, as a closing deliverable, one should call for the approval of the relevant minister, or the relevant ministers rather, of these plans, and the answer here is a simple no. For major public entities at least, The corporate plan and the borrowing program is submitted to the relevant minister for information purposes only. So the more meaningful or achievable CP would be to ask for a copy of the document with evidence that it was submitted on time. Corporate plans and borrowing programs can be, and they are used by lenders in their credit assessment. So they are very useful tools, but in the case of public sector borrowing, they're actually also very important from a legal analysis point of view. As mentioned earlier, once a public board, entity's board has actually given authority, or a public entity's board has been given authority to delegate borrowing powers to officers within the public entity, there must still be an actual resolution effecting that delegation. And the board resolution often refers to the borrowing program or to another document. So if this is the case, then these documents equally have to be interrogated to determine the extent of the delegated borrowing power and the extent of the authority of the authorized individuals. Quick reference back to borrowing limits that were also mentioned. They definitely are more nuanced for public sector entities than for private companies. In a private company, very often there are no borrowing limits. And when there are, it's quite simple to show that either they haven't been exceeded or the requisite authority, often just a shareholders resolution, has been obtained to in fact exceed these powers. So in contrast, for public entities, there isn't that sort of flexibility, and public entities often are subject to multiple layers of borrowing limits. For example, what Pippa mentioned already is that there are foreign currency borrowing limits for public entities that are wholly owned by the state. In addition, the constitutional documents or the empowering legislation of each entity will contain or may contain additional constraints. This could be quite straightforward. You have to borrow in accordance with your borrowing plan. But for some entities, it's much more complex, and it sits not just in their legislation, but in subordinate legislation. And it could, for example, as it is for the DBSA, include leverage ratios that have to be maintained, notwithstanding external borrowings. I'm going to turn very briefly to guarantees. Major public entities are supposed to borrow on the strength of their balance sheets, but government may and does guarantee their obligations in exceptional circumstances, for example, just to support restructuring obligations. According to the 2020 budget review published by National Treasury, government's contingent liabilities, which consist mainly of guarantees for external borrowings by SOEs, are expected to increase to 1.16 trillion rand by March 2023. A guarantee that binds the National Revenue Fund, like these, either in respect of current or future financial commitments, has to be approved at two levels. Firstly, by the responsible cabinet minister. So think public enterprises for SAA, Minister of Transport for SANRAL, but then acting in concurrence with the Minister of Finance. Practical matter here, maybe it's more logic. Where government does guarantee or intend to guarantee the external borrowings of a public entity, negotiating and drafting timelines should make provision for a parallel stream of commercial discussion and for legal input, and eventually sign off from the Chief State Law Advisor. Okay, before I conclude, one quick point on enforcement of lender rights. So when things do go wrong under public borrowing transactions, lenders need comfort that they'll be able to enforce their rights. In terms of the Institution of Legal Proceedings Against Certain Organs of State Act of 2000, a claimant who wants to institute proceedings against an organ of state for the recovery of a debt must give notice to that public organ within 6 months of the debt becoming due. So debts in this act includes debts for damages or claims for damages, whether they arise from contract, from delict, or from some other cause, but they exclude debts arising from claims for specific performance. So most claims of lenders against their borrowers would be for specific performance, pay the amount due. But there are two important exceptions. So firstly, loan agreements typically allow, or at least don't prohibit, lenders from exercising whatever other rights they have in law, and that would include damages claims. Secondly, where a public sector loan agreement is governed by a foreign law, usually English law if there's a foreign lender, then action against the borrower may be via a foreign judgment in a foreign court that is subsequently enforced in South Africa. So in this case, the Act does apply, and a notice of the intention to enforce the judgment against the public organ must be delivered to it within 6 months of the date of obtaining the foreign judgment and making application for it to be enforced locally. So in conclusion, if you forget everything I said and remember one thing only, then I think it is that the analysis for the authority and the capacity of a public sector borrower to borrow externally is far more complex than the equivalent in the private sector. And therefore, it's critical that the necessary analysis is not just done, but also presented to lenders as early as possible in the process, so that we don't do all this work and then the flow of actual loan funding is held up by closing deliverables. Thank you, witness.
Thanks, Anina. Quite useful and helpful for many of us who are in the space, so that we understand what is it that we need to look out for when we close these transactions. We shouldn't be asking for a CIPC report for a public sector borrower, which is not a company, because we're not going to get it, and it means we're not going to close that deal. Otherwise, we'd have to amend the lending documents. We have come up to now discuss look at the questions that might have been raised by you. If you have further questions, please do raise them. I have some questions that I will put out to my panelists here. The first question, interestingly, relates to where, for example, there has been an approval for a loan or funding, and then that funding is restructured. When it does get restructured, does the SOE concern need further approval under the PFMA, or will the first or the initial approval still be applicable? Pippa, do you think you can be able to assist on whether there would be a need for a further approval where there is a structuring of a funding transaction?
Sure, I'll give it a try. So I suppose it depends on which approval you're referring to. So if there is a board resolution or a decision of the Minister of Finance to authorize an entity to borrow in specific circumstances, I think you'd have to look at the approval itself in order to see what's covered. I mean, certainly from a government guarantee perspective, so also if there's a government guarantee, to see if the guarantee would cover the extension of the loan or the changes in the lending contract. And certainly if there's an extension either of the maturity date or of the total commitments, you would normally need to refresh those approvals, or if it took the institution beyond its borrowing limit. So yeah, I think in general, you can't assume that the original approvals would continue to apply, and you'd have to have a look at the extent of what they authorized at the time and whether what you're doing takes you beyond that initial authority. So that's, I think, would be the general rule.
Thanks, Pippa, and I think that makes perfect sense, because the restructuring might actually go beyond what was approved at the time. So it makes sense that you need to look at what the terms of the restructuring to see if it still falls within the initial approval. The second one, I think also, Pippa, it may probably well fall within your topic. It's about intercompany loans between SOEs, where, for example, an SOE which has a subsidiary gives a loan to such a subsidiary, would they, in those circumstances, will the SOE require approval from the minister, or will a board resolution or board approval be sufficient?
Thanks, Witness. So, as I said in my presentation, a subsidiary of an SOE is considered to be an SOE in the same category and with the same powers and duties as its parent company, which is specifically named in the schedules. So, the borrowing powers of the subsidiary would be the same as those of the parent. So, if it's a Schedule 2 parent, then the subsidiary is a Schedule 2, and they would be able to borrow through their accounting authority without restriction, subject to empowering legislation. But if they want to delegate that, or if the board wants to delegate that authority, they would need the Minister of Finance's approval to do that. So you'd have to look at the parent company's Minister of Finance approval in order to see whether it covers subsidiaries or not. And then similarly, if it's say a Schedule 3B public entity like PRASA or a water board, where the parent has been given authority to borrow within certain limits, you'd have to check that Government Gazette notice in order to see whether the subsidiary has the same powers. So it's subject to exactly the same rules, and there's no exemption for intercompany or interfamily loans. And in fact, the PFMA doesn't regulate the relationship between parent public entities and their subsidiaries very clearly. So there are a few grey areas about how some of the provisions of the PFMA apply to subsidiary entities, and whether, for example, where a ministerial approval is required, a subsidiary would go directly to the minister for that approval, or whether it would have to first get the approval of the accounting authority of its parent, and then that approval request would have to go from the parent board to the minister. So there are complicated questions like that arise, but I think generally the answer is same rules apply to a subsidiary.
Thanks very much, Pippa. I think that's quite clear. The next question, it's more really about the Companies Act, and I wasn't one of the speakers, but I can take this question for reasons that I'm here. The question is whether entities that have their own statutes, such as the IDC, which has the IDC Act, and the PIC with the PIC Act, will be bound by the Companies Act as state-owned companies. So, and this is something that we also discussed last year in our first series of these webinars, to distinguish between companies or SOEs that are companies and SOEs that are not companies. The PIC certainly is a company. It's established in terms of the Companies Act, established in terms of its own act, but it's also a company in terms of the Companies Act. It has an MOI. It's bound by the Companies Act. It's bound by the PIC Act, certainly. The IDC it's one of those gray areas in the sense that it doesn't even have an MOI. It's not a company in the sense that arguably the way the IDC is set up, it's not a company, and when you look at the IDC Act, having looked at it at some point, there's a provision that says that the registrar of the companies at the time would have had to include the IDC in the register of companies. It doesn't look like that has been done, and the IDC as an entity is not regarded as a company. It does not basically conduct itself as a company from the way I know the IDC and having dealt with the IDC. Those are the questions that we have, and we would like to thank everyone for coming today and joining us on this webinar. And hopefully when we do have the next one, we would love to have you as part of our audience. And thank you very much. Thank you to my panelists And thank you to everyone. Have a good day.